Good evening. My name's Megan Rose. I'm with Metropolitan Family Services,
I'm Hema Sarma. I'm with Family Rescue.
and we're here as guests of the Wiley Resource Center this evening. The Wiley Resource Center offers a monthly legal clinic the third Saturday of each month. The next legal clinic will occur on July 19th at 12:30. If you're interested in signing up for the Wiley Legal Clinic or would like to ask questions or hear more about it, please call 773-738 1480. Again, that's 773-738 1480. Hema and I are here this evening to talk about domestic violence and the resources that are available within the city of Chicago.
And Megan had introduced us. We are court advocates that work at the 555 West Harrison building. And the 555 West Harrison building is the domestic violence courthouse in the city of Chicago. And our agencies, both of ours, have court advocacy programs in the building.
That's right. So, Hema, if we could talk a little bit about what type of relief or what type of help is available at 555 West Harrison, which is the City of Chicago Domestic Violence Courthouse.
Right. Well, first of all, to explain that we are what a court advocate is a person who is trained in domestic violence and in resources and advocacy, and basically they help people through the courthouse and the 555 West Harrison building obtain orders of protection and other remedies regarding domestic violence. And one of the things an order of protection is what somebody might say is a restraining order. It's an order of protection in civil court can help protect somebody in a domestic violence situation from further abuse, from harassment, keep somebody away from them at all times, no contact, no phone messages, no coming to somebody's house or job, and stay away from them or anyone in their household that may need protection from abuse. And that is for their civil orders of protection, where somebody can file that in civil court and ask for that relief from a judge.
So, an order of protection is also available through participation in the criminal misdemeanor process. So, for orders of protection, the first requirement is that that the victim share a domestic relationship with the perpetrator. And domestic relationship is defined pretty broadly in Illinois, but that can be someone that you're married to or used to be married to, someone that you have a child with, or allegedly have a child with, someone you dated or used to date, someone with whom you were engaged and you're no longer engaged.
And also relatives, somebody who you are related to by blood or through marriage, but so that could be parent, a child, an adult child, a sibling.
Right. And people who share a blood relationship through a child. So, one more we're forgetting are roommates or former roommates. Also, there are some protections for adults with disabilities who are looking for protection from their caregivers. So, if there is that domestic relationship, the Cook County State's Attorney's Office has the opportunity to issue charges, criminal misdemeanor charges. And at 555 West Harrison, those misdemeanor charges generally would include things like an assault, domestic battery, a criminal damage to property or criminal damage to vehicle, telephone harassment, child endangerment, and then there are also criminal charges for violating an order of protection. So if there's a domestic relationship and the state's attorney is interested in putting forward charges, a victim would have to have a police report. So that police report is essentially the ticket for someone to speak with an assistant state's attorney about the possibility of criminal charges. If the state's attorney approves those charges, then the state's attorney will be acting as an attorney in the case representing the people of the state of Illinois. So they won't necessarily represent the victim in that process, but they will speak for the people of the state of Illinois and pursue prosecution of those criminal charges. As a part of participating in that process, the victim can obtain an order of protection. Similar, actually, the exact same order that's available in the civil court.
Yeah, they're the exact same form, and there's the same type of protection that's available. But in the situation, if somebody the state's attorneys don't approve the charges, they don't feel like maybe the evidence is strong enough or that they can make a case in that situation, or a person doesn't want to pursue charges. Suppose somebody just wants to go to court to get protection. They don't want to put somebody in jail at that time. They just want to protect themselves and they want to stay safe. They can come and file that civil order I was talking about. Again, same piece of paper, same forms, but they can get protection from abuse from that person and protection for themselves and anyone who lives with them.
Okay, so what I'm hearing is it's a court order, right?
Yes.
So how soon does someone see the judge after coming to the courthouse for the first time?
If you're coming to that courthouse at 555 West Harrison, you can see the judge on the same day that you come to court, because you are coming there for what is called an emergency order, usually if you need it that day. Basically, you're saying that without this order, I'm in danger of further abuse immediately. And without this order, I'm fearful that more abuse will be coming. And if I tell that person before I leave here, they will hurt me or try to stop me from coming back to this court. So they want to give that person protection that same day so they can leave there knowing that they're protected by the law at that point. And like you said, if somebody violates one of those orders, either in the criminal order of protection or the case in civil court, police can prosecute for a violation of an order. So it becomes criminal sometimes, even if it started in civil court.
Okay. So it sounds like the emergency order protection can be obtained without telling the other side that I've gone to court. How
Yes.
long is that emergency order good for?
Only for up to 3 weeks. It's a order that can be issued for only up to 21 days. So 14 to 21 days is a typical amount of time. And that is because you go to court and you don't tell that person, but they need to give that person a chance to come to court to make their own arguments about why they don't need the order in place. So at that time, that's when they send the sheriffs out to serve that person. And that's why they give it the 14 to 21 days, to give the sheriffs time to go out and serve that person. And some people ask this all the time. The sheriffs are going to serve paperwork. Those particular sheriffs for the civil cases are not going to arrest that person unless they do something criminal at the time. It's for service purposes. So somebody might see sheriffs and think arrest, but that is how civil orders are given to people that have the orders against them.
Personal service sounds like is the requirement.
Exactly.
Okay. So let's say I obtain an emergency order through civil court, and the sheriffs notify the other side. What can I expect on that return court date?
Well, if you come back to court on the civil order of protection.
That's right.
Yes. Then if that person is served, that person who you have the order against, who's called the respondent, may or may not show up to court. If they don't show up to court, they're not arrested. That it just means that the person who filed the order, the petitioner, can get a longer term order of protection. That order is known as a plenary order of protection, which can be issued for up to 2 years. So if that person doesn't show up to court, the person filing, and they were served with personal service by the sheriffs, typically, then they can get a default plenary order. The other thing that can happen is the other side, the respondent, shows up to court, and that respondent can then ask for a hearing, which is what you think of a trial, in which the person filing the order tells their side, and then the person who got the order against them, the respondent, tells their side, and then the judge makes a decision on which side the judge believes more. So it's...
So Hema, I've seen a lot of episodes of Law and Order. Is the burden of proof the same in the civil order of protection case, or is it something different?
Oh, it's different. And I know burden of proof is a weird thing, but they say, that guilty beyond a reasonable doubt, that is only for criminal court. Guilty beyond a reasonable doubt is a stronger burden of proof. That means that the side asking for the order or the asking for the charges has to really have a lot of evidence. And the judge has to hear that evidence to then say, okay, you've really proved your case beyond that reasonable doubt. For the civil cases that I was talking about, it's really, if you want to think about it as percentages, like 51% over 49%. The judge just has to believe the person a little bit more than the other person. But it's, no matter what, it's good for the petitioner who's getting the order to have all of their evidence with them. It's like you're proving a case. So if you're saying that person has been harassing you through text messages, it's very good to have those text messages with you. If they have, if you can remember all of the things that happen, you need to be able to prepare to tell the judge all the reasons why you need the order. Because the judge needs to hear your case. Because the judge still has to have some evidence that there is abuse happening enter that order of protection.
Okay.
So, but what is it like in criminal court then? What's the burden of proof there?
Great question. So in criminal court, once the state's attorney has decided to issue charge someone, they will go up to court and see a judge the same day, much like in the civil process. But the state's attorney will be asking the judge for either a warrant for the defendant's arrest or a summons, which is a strong invitation that the defendant come to court. Typically, they're hoping for a warrant, which would mean that that defendant would be arrested. At that point, once the defendant is arrested, I'll walk you through that process in a moment. But at the same time that the state's attorney is asking the judge to allow the charges to be put through and asking for that warrant, they may also be asking for an order of protection to protect that complaining witness through their participation in the criminal case. And that order of protection looks just like an order of protection that is issued in civil court. So that can be a no contact by any means order of protection. That can list a home address that the defendant is ordered to stay away from. That can list a place of employment that the defendant is to stay away from. That can list other people as protected parties, including children of the parties or the children's school. So the orders of protection in civil and criminal court may end up looking a lot alike. The difference is that the assistant state's attorney asks the judge for it on behalf of that complaining witness. So,
Can I ask you
Sure.
a question? You mentioned something about protecting addresses. What if the person who comes in has left? What if they live together and
Sure.
she took off and she's at a shelter, or she doesn't want him to know where she's at? What does she do then?
That's a great question. So the order of protection process allows for a victim to ask the court for protection and leave her address off of that paperwork. She has to provide an alternate address so that if the defendant files a motion or there's something that occurs in the case, that she can be notified by mail. But all she needs to provide is a mailing address. So if she's in shelter, if she's staying with a family member or friend, and that individual, that abuser, does not know where she is, then she would be able to participate in the court process without giving her exact physical location.
Well, that's good.
So, if the case in criminal court proceeds, typically the defendant will be arrested if a warrant has been issued, and that defendant will be brought before bond court. Bond court is a place where a judge can set the conditions for that defendant's release. So the defendant could post a certain amount of money, and sometimes that's not even required if it's a first offense or that defendant doesn't have a criminal background. That defendant can be out of custody, so out of jail, awaiting their first court date.
I've only heard the term bail.
Mm-hmm.
I mean, that's what most people would call it. What's the difference between bail and bond?
There really isn't a difference. So
Okay.
bond court is what we call it here, and typically if bond is set at $5,000, in most scenarios, that defendant or the defendant's family or friends can post 10% of that to obtain, to have the defendant released while they're awaiting their next court date.
So that is bail, like you're paying money to get somebody out of jail.
That's correct.
Got it.
So at the first court date in criminal court, typically the defendant is aware of the charge, and many times the assistant state's attorney may make an offer for that defendant to plead guilty. And offers to plead guilty in the courthouse, in the City of Chicago Domestic Violence Misdemeanor Courthouse, may include probation, supervision, domestic violence classes, so a 26-week program where that abuser would learn different coping strategies for dealing with conflict in their relationship. It may include something called a substance abuse evaluation. Many survivors of domestic violence report that the violence increases in lethality or escalates, gets worse if that person's been drinking or using drugs. So those are some of the things that the state's attorney may offer for that defendant to plead guilty to the charges. Often, what's also negotiated through a plea would be an extension of that order of protection. So Hema mentioned that an order of protection by law, by statute, may be granted for up to 2 years. So typically offers for a plenary order of protection to be entered as a part of ending that criminal case may be for 2 years or 1 year. That's typically the duration that we see out of criminal court.
And what if they don't take the plea?
If the defendant chooses not to plead guilty, then that defendant may demand a trial. So a trial can be either a bench trial where a judge makes the decision about whether the state's attorney has met their burden, so shown that that defendant is guilty beyond a reasonable doubt, or the defendant has a right to request a jury trial. And a jury is a group of individuals from the community who are asked to come and listen to the evidence and testimony and make a decision about whether the assistant state's attorney has proven the case beyond a reasonable doubt.
Like Law and Order.
Like Law and Order.
Okay. So this place seems sort of confusing. I mean, there's so many options that we already just talked about.
Right.
What is available for somebody who comes into that building and doesn't know what they want? They don't know they want to press charges. They don't know if they want to go to civil court. They don't even know really what they're there for. The police just kind of sent them there. Here's your police order. Here it says 555 West Harrison. I'm here now.
That's that's a wonderful question. Many people who find themselves at the domestic violence courthouse, I believe we have a caller. So I'll take a moment to answer your question, then we'll move to the caller. Pardon?
Ladies, most people take a conviction plea guilty. Is the reason most people do that is because they may not have the resources to hire an attorney. They prepare their case, and a large percent of the people that's sitting in jail, because they don't have the bond money. All right, because a lot of times they do that because it's not because they may be guilty, because that may be the easier way and quicker way to deal with it. And that's the reason why a lot of times the prosecutor have a high in terms of conviction rate in terms of domestic violence.
I think that's a really great point. And actually, I'd like to go a step further on that point and say that, it's kind of incredible when you think about the crimes that are being charged out of 555 West Harrison are misdemeanors, punishable by a maximum of 364 days in jail. And many defendants awaiting their day in court may spend close to that amount of time or perhaps more than that amount of time. And if they don't have the sufficient resources or their family or friends don't have sufficient resources to post that bond.
And can I make one other quick comment?
Of course you can.
When they have all those cases and you got those judges, they say we need to resolve these cases as quick as possible. And it may not really have anything to do with guilt. They just want to resolve those cases because otherwise they be piling up left to right.
Well, that's another excellent point. I think the sheer volume of cases that are processed through the circuit court system here in Chicago is tremendous. But just to go back to your first point, I think that you raise a really great point in that many defendants who are ultimately maybe exonerated through a bench trial or jury trial may end up spending more time in custody than they would have been sentenced to had they been found or pled guilty.
And that's one of the reasons why the county jail is so crowded.
Well, I'm sure that's one of many reasons.
There's one of many reasons.
I think certainly that is a concern from a social justice perspective.
Now there is, and I just will say, although I'm not as familiar with the resources at the courthouse.
One point. Most people that get people that serve an order of protection, the majority of people, they obey those order protections.
Oh, I wish that were true, caller. I wish that were true.
Okay, maybe we could deal with the data later, because there's some people say there's statistics. How you put it? There's statistics and then there's lies. Take care.
Well, I know he's still not on the phone, but what I wanted to address the point is that there is a public defender's office at the 555 West Harrison Courthouse. So if somebody cannot afford their own private attorney in that courthouse, there are public defenders available to help them. And so they are there just like our offices are there. They are there located in the building and will be assigned to anybody who shows they don't have the income to hire their own attorney.
That's right. The judge will appoint a public defender if after, some questioning realizes that that defendant is without means or resources to hire a private attorney. Additionally, there is typically a bar attorney who makes him or herself available in the courtroom most days when criminal court is in session. And to receive the services of the bar attorney, the defendant need only really forfeit the money that they posted for bond. And typically that is another way of securing representation if the individual doesn't qualify for a public defender, yet lacks the means to hire a private defense attorney for the duration of the case.
Yes. But I do agree that the courthouse itself, again, can be chaotic, and things are happening there. A lot of times both the victim and the defendant don't always know everything that's going on. The cases go very fast. The judges say a lot of things quickly. The state's attorneys and the public defenders might have a conversation that both sides don't really know what's happening. And again, walking into that courthouse, you don't maybe know what's happening. And so part of our job, our main job as advocates there is to be support to people who come in for protection in that courthouse, but there are other resources at that courthouse available.
Yeah, that's right. So the majority of people who are utilizing the court at 555 West Harrison are pro se. Pro se means they don't have representation. And so court advocates are a great resource for someone who is thinking about pursuing either process, not really sure, really wanting to explore their options, what's available to them as a victim of domestic violence under the Illinois Domestic Violence Act. Like Hema mentioned, many times people are sent to the courthouse by the police or referred to the courthouse by a friend or family member who may have had a case there in the past. So there is a great new resource at 555 West Harrison. There are 4 individuals. They're called Resource and Information Advocates, and they float all over the court building, specifically concentrating in the area where most people are preparing their paperwork to go up and see a judge. But they're called RIAs, Resource and Information Advocates. And the RIAs are really, they're in the building, they're available to provide brief services, so to counsel people about their options, to safety plan if that victim is in danger, whether she files that order or receives that order or not. They also connect people to other resources for longer term support, such as court advocates. 3 of our 4 RIAs are bilingual Spanish speakers, so they're able to assist people for whom English is not a first language. So the RIAs are a really great program funded by the city of Chicago and offer a tremendous link, I think, and fill a need and gap in the court process.
And I'm wondering if we have another caller.
Ma'am, I want to make 2 other comments if I am permitted. There's 2 things people I consider before they before they make that guilty plea. One, you may, depend on your situation, every situation is different. You may want to fight because it can affect your employment history, maybe even your credit. And the other thing is, in quite recent years, whatever, you may have to give up a DNA sample and then go in something like CODIS.
Well, the DNA sample is not something that's typically a part of a criminal case out of 555 West Harrison. I can't speak to felony cases processed at 26 in California.
Or paternity cases.
Or a paternity case that may be a part of a domestic relations case. However, I would say that's an excellent point, that before pleading guilty to any offense
Be informed.
Be informed.
Exactly.
And that's certainly why our public defender system exists, and certainly why
But that's one of the things that make, like with paternity right now, a lot of people don't know this. Even in terms of paternity cases, guess what? Your DNA is taken and put in some database someplace. And if you
I'm sorry to interrupt you, caller. I wish we had more
I'll be
time.
quick. Thank you. Bye.
Thank you. I wish we had more time to talk, but we want to make sure that people know about our court advocacy resources and the support we can provide. So I'm Megan Rose with Metropolitan Family Services.
I'm Hema Sarma with Family Rescue. Both of our agencies have websites, and you should please look them up to figure out what more resources that are available to victims of domestic violence.
Or stop by and see us. We're both in Suite 2200 at 555 West Harrison. If you have questions that haven't been answered by our presentation today, I'd like to direct your attention to the Domestic Violence Helpline, and that is a resource that is available to you in many languages, and that is a resource offered by the City of Chicago, but it connects people to resources statewide. 1-877-863-6338.